When people initially go and see solicitors, one of their first concerns is costs. So it's always a good idea to try and keep control over it. There's lots of different ways of doing it, but you should be very upfront with your solicitor about talking in relation to costs. So some of the options that are available these days is that you can have fixed costs, you can set a credit limit, you can keep costs under review generally, and you should also have a chat with your solicitor about how to keep costs down. So what can you do to keep your costs down? I think the first thing I would say is have a chat with your solicitor about making sure that you know what your cost liability is going to be. And then the second layer is actually to discuss how to keep the costs down. So this could be anything from keeping your calls down to a minimum. Don't ring your solicitor 10 times a day. Don't keep sending emails. If possible, keep your communication to email. It's usually cheaper. If you need to have a conversation with your solicitor and you know it's going to be a long conversation, make an agenda, send it to your solicitor, and then at least you can keep to the agreed items. If you're going to have a meeting, again, prepare an agenda. All these things just reduce the amount of time your solicitor spends on the matter. Yeah. These days, a lot of people represent themselves, and if you are legally represented, it can cause a bit of an issue. So quite often, if someone is representing themselves, the court will give them a bit of leeway. What that means is that sometimes they will be making calls to your solicitors, discussing issues that are not really relevant. If they had been legally represented, those costs would not be incurred. And ultimately, if you go to a hearing, the judge might expect you, because you're legally represented, to pay for your solicitor to prepare the paperwork for the hearing. So it seems unfair, but generally speaking, you should be prepared to pay extra costs if your partner or spouse is not legally represented.
At the Law House, we seek to always find the most sensible and fair settlement as quickly as we can. Sometimes, unfortunately, our opponent doesn't cooperate in this. We are unable to compel opponents. The courts can compel opponents to do the right thing and to transfer property or to see children in a particular time and place. But during the negotiations, compelling somebody to do something is often locks up the negotiations. We wouldn't use those terms, compelling somebody to do something. We seek to find fair and equitable solutions that work for everybody, because ultimately that is normally in our client's best interest.
So legal fees can start mounting up quite quickly, and a lot of people will not necessarily have the money available to pay the costs. There are a number of options available to try and fund the fees. I would always say the first option should be to try and speak to family and see if you can borrow money. The only reason for that is simply that you would have flexibility about paying it back. If that's not an option, then maybe a conventional bank loan where you have a fixed sum that you're borrowing and fixed monthly payments. So that helps you budget. If none of that is available to you, then you can obtain what's called a litigation loan from private banks. They generally attract higher interest rates, but it means that your solicitor's fees are paid and you then repay that when you receive a capital sum as part of a settlement. Are there options available to pay fixed costs? At the Law House, we offer a good range of what we call fee options. So we can do work on a fixed fee basis. We can work to a credit limit. We can agree to keep costs under review at regular intervals. So there's options available, and we can actually mix and match those options. At the Law House, we take the view that costs are something that should be discussed openly and frankly from the outset.